Thank you very much, Chief Justice. Just two questions to Judge Mbenenge. The first one is just on the case flow management. You did earlier speak to the disproportionate load of cases in the division, in the various sister divisions there.
Yes.
Where I thought that this case flow management is a device or instrument to try and regulate the ease with which matters are heard.
Yes.
Don't you find it a bit queer that in the Grahamstown and Port Elizabeth divisions, there seems to be lack of movement in the matter? I don't know if I'm characterizing it correctly.
Yes.
But there does seem to be what in me reads like reluctance. Don't you find it?
I think, Premier, we've gone past that now. Everybody will be afforded the opportunity to state a view on a matter. I think there was a misunderstanding of what norms and standards issued by the Office of the Chief Justice were about. There was this view that this is a permissive dispensation, yet it is an essential tool to the running of cases. So I would say I found it queer then, but the way I see it now, people out there are repentant. I read this particular letter, particularly that paragraph where the endeavor is sort of to streamline this dispensation so as to deal with, certain cases, whereas it should be as wide as possible. But at the end of the day, Premier, it is for AJP to influence change, even among those who tend to resist. Now, I'm saying this in the context that indeed it is so that there was resistance initially, but after some time, the idea was embraced.
No, my last one is just on the attributes you referred to earlier when you spoke. And I must say that all the other recommendations that come, they really are very impeccable and they make a very flowery outlook. Just one question for me. In the course of your career, did you have to manage disappointment? And perhaps if anywhere there's any example, why I'm asking is that between assertiveness and at times perceived arrogance or arrogance, there is somewhat a fine line.
Yes.
But how do you generally manage in such? Have you ever had to manage disappointment?
It would sound artificial for me to say that during the best of times when I thought I was assertive, I was perceived to be more on the arrogant side. I do remember on one occasion, the then acting Judge President of Mthatha, Justice Petse, who is somebody that I relate with at a casual level. He gave it tough a little bit to me when I was arguing a matter, and I ended up reacting in that particular scenario. And later that day, I picked up a phone and spoke to him and said, I was thinking I was assertive, but now that I had reflected on it, I thought I was a bit arrogant towards him. And he responded by saying, yes, you were less than diplomatic. So I'm not an angel. CJ, you'll remember that during the best of times, Moses lost his cool. You remember that? He lost his cool. Sorry, because I'm mentioning this because there's something that's a bit common between the two of us. He lost his cool. And he ended up not touching the promised land. But we read scripture and find that eventually he was taken to go to heaven. I don't want to delve into that. I know that we differ when it comes to these things, but I'm just mentioning it in passing. You won't get my confirmatory affidavit, Commissioner Malema. I have had those moments, and AJP Ntlangulela, one of the most patient of judges, will recall that there were moments where I was a bit rough. And I've had to learn from those who are cool and collected and calm when they do things. Those are odd moments. They have happened. President Maya, how did I behave appearing before you? There may have been those moments. Anyway, the long and short of it, that would have been an exception to what generally prevails. But let me harp on one thing. The ability to manage conflict is a gift that I have. The fact that if I see you and when observing that you are grumpy towards me, I'm very quick to approach you and say, it looks like there is this cloud that has descended between the two of us. And I've lived that life. Thank you.
Thank you, Chief Justice.
Thank you, Premier. And Acting Judge President Langulela, I apologize. I wasn't aware you were acting as Judge President. My apologies. Judge President Hlophe.
Right, thank you very much, Chief Justice. Firstly, let me disclose to this commission that I have known Judge Mbenenge for many years. We first met in Amtata in 1990 when I was an academic, and over the years, we have had a very cordial relationship. I have two questions for you, Judge Mbenenge. The first is this. We have a problem in the profession about skewed briefing patterns, whereby black lawyers, attorneys and advocates do not seem to have access to good work, which in turn prepares them to be good judges at the end of the day.
Yes.
Because lawyers of today are judges of tomorrow.
Yes.
Right? That is the first question. The second question relates to case flow management. I would like your views in respect of the following essential tools of case flow management, preferably in the following order. 1, pre-trials in both civil and criminal matters. Do you believe they're an essential tool, and how? Let's unpack that. 2, court-based mediation. Court-based mediation as an essential tool of case flow management. 3, continuous roles. That is also an essential tool of case flow management. 4, limiting the time of counsel to present argument in court. Limiting counsel's time to present argument in court. And finally, limiting the heads of argument. Before you answer those questions or before you elaborate in that regard, I just want to say, as far as case flow management is concerned, I come from the school of thought which says it cannot be left in the capable hands of individual JPs to do their own things, different things in our different corners. It must be coordinated, there must be uniformity, all of us must do exactly the same thing so that the practitioners who appear in Gauteng, who have to go and argue a case in Grahamstown, know exactly what is expected in Grahamstown, because the same thing is done here. If they go to the labor court, exactly the same uniform practice must be adhered to. Right. Against that background, I would like you to deal with those questions.
Thank you, JP. I don't believe that when it comes to briefing patterns, the country has achieved has achieved or reached the threshold or the requisite standard. Time and again, you will see that commercial work will still be in the hands of whites and white firms who still prefer briefing white counsel. Something could be done about it. We would like to see senior counsel roping in black females or black counsel to impart their skills. The state attorney is doing its best. I've seen it in Umtata. The state attorney is doing its best to spread the work and thus empowering those who practice in that division. look at matters appearing before the Constitutional Court, for instance. There will be instances where there will be a mighty white senior counsel, at times with even 3 junior counsel handling a matter, none of whom belong to the category of people who are supposed to derive a benefit from transformation. I'm still of the view that there is still a shortcoming when it comes to this, the issue of briefing patterns. Coming to case flow, yes, we need to have uniform tools, as you've pointed out. I must not appear in Port Elizabeth and then find a different set of rules applicable there. It's a situation where, if you look at the norms and standards as the Grundnorm, or let me say the fountainhead of case flow, you get an idea that it should be codified somehow. What is applicable should be applicable the country over. Court-based mediation is possible, of course, not in all matters. There are matters that may be subjected to some form of mediation. Let me take the odd case. You know, for instance, burial cases. You still find those cases out there in Mthatha, where people fight over dead bodies. You know, in instances like those, mediation is called for. An approach that says you are blood relatives. Don't ever think that if you bury, then the estate will go to you. It's governed by different rules altogether. You may as well find that you bury today and then tomorrow the estate goes to somebody else altogether. To ensure that families live in harmony. I'm making that as an example. And then a continuous role is something that I'm very fond of. Is something that I believe will go a long way towards ensuring that civil courts and criminal courts are well run, matters are disposed of, they don't spill over to the following term, and they are finalized within a particular term. Limiting time for the presentation of argument is a good thing. It is good. CJ, you did it most of the time. I appeared in the Concord. You called counsel to chambers. You engaged them. It was not an arbitrary decision. You would say, for instance, Mr. So-and-so, you are for the appellant. What about 30 minutes? So on and so forth. We've seen it happen, and I believe it's something that could be invoked even in our courts of first instance. Heads of argument, that is governed by the rules. The rules make it clear that you are not here presenting a thesis. It's actually just heads of argument. It's the points that we'll be raising. But at the same time, it's always good for whoever pens heads of argument to refer to everything that they will be relying on when they present a matter. I think that covers the salient features of your question, JP.
Thank you, Judge President.